Good morning, guys. And thanks for giving me the opportunity to consult on your legal case via this web conference today that we have with your legal team. Um, as you know, my name is Mark Raven and I am from Legal Consulting. So we're a small based legal consulting firm in Perth that consult to other legal solicitors and barristers around the country on different tort law liability cases. And it's a pleasure to consult today on your case. So, as I did say just before, we're a legal office that specialises in tort liability law, and that's what we'll be focusing on today. So, just a basic rundown of what tort law is. Tort actions are based off three main aspects. So, that is an act or omission, an infringement on a legal right, and an action for damages or compensation. And in your case, we're looking at seeing if you can sue for negligence against San Francisco Zoo. And negligence is whether the defendant has failed to achieve the standards of care imposed by the law. So that's what we'll be focusing on today. So, breach of duty of care under tort law focuses around two key questions. And number one, what is that standard of care? And number two, has that standard been breached? So they're the two key questions we need to ask ourselves when looking at the duty of care and if that's been breached in this case. Standard of care is focused off the Civil Liability Act, or commonly referred to as the CLA, and this is a piece of state legislation. In Western Australia, we have our own piece of CLA legislation, and the CLA is based around the general principle that a person is not liable for harm of someone unless the following three things happen or have occurred. And that is if the risk was foreseeable, the risk was significant, and a reasonable person would have taken steps or precautions to mitigate against this risk. So they're the three key aspects when it comes to standard of care to see if a standard of care has been met under tort law, which has been based off the CLA Acts. Risk of harm is another key feature of duty of care, and if that risk of harm was potentially seen or could be foreseeable. And that's really evident in the case of Uniting Church versus Miller, which is a very well known case, is where Miller, the plaintiff, was a student and she attended a school ran by Uniting Church, and they went to a swimming pool here in Perth, and the school or the swimming coach instructed the plaintiff Miller to do a dive, a certain type of dive in this quite shallow part of the pool, where there's signage around the pool saying no diving, etc., etc. So the pool wasn't negligent, but it was the school where the school should have seen the risk that was happening. So Miller um, had a quite severe injury from her dive in the shallow water, and the school should have potentially seen the risk of harm that was happening here and should have probably mitigated against it, not instructed to do it, or really just stopped the whole activity. But the school ought to have seen that risk and then mitigated against it. So the school was found liable in this Uniting Church versus Miller case, and that's really where the basis of risk of harm has come from. So under duty of care, the risk needs to be foreseeable, um, and under CLA, they say that risk needs to be foreseeable, but also not very likely to happen as well. So if there's an event that you can probably see happening, or you probably think, oh, it could happen, but it won't, or it's very unlikely to happen, then you still need to mitigate against it or take steps to prevent that risk. And that's seen in the case of Wyong Shire Council versus Shirt. Shirt, the plaintiff, did some water skiing in a lake where the council had put a sign up saying danger deep water. And the water was actually quite shallow in parts of that lake. And for water skiing, you need quite deep water. So Shirt, the plaintiff, had some injuries from water skiing in such shallow water. And then he sued the Shire for lack of duty of care in this case. The council, yes, it was probably very unlikely that someone would hurt themselves water skiing in the area, but still they should have foreseen that potential risk of happening. And that's really evident here, where that's where the basis of the risk needs to be foreseeable but not very likely to happen has come from. So the council was found negligent here, and this is quite similar really to the case that we're looking at today in terms of the San Francisco Zoo. Yes, the risk was very unlikely to happen, or the event was very likely to happen, but they still should have potentially seen the risk of happening and mitigated against it. So, on to today's case. So, you already know all the events that have happened, but we'll quickly go over them again because you're the family members and the legal team of this. So, we won't go over too much in detail because I know this is pretty traumatic. But onto your situation. So, on this attack on the 27th of December 2007 in San Francisco Zoo, in my professional opinion, I do believe that there's a very good case to sue the San Francisco Zoo for a clear act of negligence and breach of duty of care. In the documents I've read through from the police and investigations that other bodies and government bodies and the police have ran, it is clear that the enclosure of Tatiana the tiger was not fit for such an animal, with the enclosure walls only being 16.5 feet high, where the industry standards are 18.5 feet. So that's a clear breach right there, that the enclosure was not up to scratch, or the enclosure just did not meet standards, and thus the public were not safe, because them standards are to keep the public safe and to keep the animal in its closure and to keep the animal safe, obviously. And this is quite clear that they have not kept up to standards, or they have just breached their standards, which it is a clear breach. 3 feet is quite a big difference in the enclosure height, and thus the public were not safe. And this breach is quite similar, really, to the case we just covered before, which was the Wyong Shire versus Shirt. Yes, the San Francisco Zoo may have never thought that Tatiana the tiger could escape, but the risk could have been foreseeable. And same as the Wyong Shire Council versus Shirt, the council should have foreseen this risk. Yes, the water skier was very unlikely to hurt himself, but they still should have foreseen the risk. And San Francisco Zoo here, yes, it was very unlikely that an animal would escape from its enclosure. But if the enclosure is not up to standards, or the walls aren't high enough, then potentially, yes, that risk could occur. So they need to take steps to prevent this from happening, thus have an enclosure that is almost tiger-proof, if you know what I mean. So that's our first breach of duty of care. There's another one that we're about to cover. So the other breach of duty of care that I said that we would cover in this case of Carlos is that the 3 boys were left in the zoo on their own after closing time. And any reasonable person would have requested them boys to leave, or the staff should have forced them to leave there. If you have a business and let's say it's 5 o'clock and it's closing time, you don't have your patrons or your clients sitting around still in your shop or retail business after 5 for no real purpose. And the staff ought to have known the potential risk of having these 3 boys in the zoo on their own after closing time. And that's a clear breach. The zoo should make sure there's no public or patrons left in the zoo after closing time. And this risk or this breach is quite similar, really, to the Uniting Church case that we covered before with the Uniting Church versus Miller. In that case, the staff or the teachers should have known the potential risk that could have occurred by having Miller or other students dive into such shallow water. And in this case, the San Francisco Zoo staff should have known the potential risk of leaving public or patrons in the zoo after closing time. And that's really the breach here. They should have known the potential risk of what could have occurred, and then eventually did occur, which is quite tragic. So as I said at the start of this web conference or presentation, there's 2 key questions that need to be answered around breach of duty of care. And number 1 is, what is the relevant standard of care? And the other question is if the standard's been met. And to answer the first question, what is the relevant standard of care here? Well, the public would expect the enclosures to be safe for the public to view the animals, and the animals will not get out. Um, and the public would also expect the zoo to keep up to industry standards to make sure that all the enclosures are kept up to the industry or government regulations. And the other standard that the public or any reasonable person would expect would be that the zoo would request patrons to leave at closing time, or force patrons to leave after closing time. You can't be in a zoo after closing time unless you were there unlawfully, which these boys weren't. So that is the other relevant standard of care. Then we'll answer to see if this standard has been met or hasn't been met. So the other question that needs to be answered is, has this standard, which we just covered before, been met? And in short, no, it hasn't. The staff did not insist the boys to leave, or any other public that we know of, to leave the grounds after 5 or before 5 to say, oh, it's closing time in 10 minutes, you've got to leave. So that's one that has been met. The other big one is that the enclosure was not kept up to industry standards, and thus the tiger, Tatiana, did escape. So that's a big one. When you go to a zoo, you expect like a big glass wall and you can see the animals, and you don't expect the animals to be able to escape. So this is a clear breach that, or standard of care that has been kept, is that this zoo has not kept an enclosure for these animals so they could not escape. Thus, the public were not kept safe, or were not safe at any time in this zoo. So that's another key breach here. So in conclusion, we've indicated that the zoo is negligent in this case towards breach of duty of care towards Carlos and his two friends, because you can't remember, it's just, I know we're here focusing on Carlos, but the other two friends have had the same duty of care breached. So I would strongly recommend your legal team, who I'm assuming are in the room today that I'm speaking to pursue a action for negligence, breach of duty of care against the San Francisco Zoo. And in my professional opinion, you will have a very strong case if it's persuaded properly and the right facts are presented before the court. So good luck with the case. And if you need any questions, as I said, my name is Mark Raven, and I do work for Legal Consulting. So you can always come and see us within Perth, or give me a phone call or an email. Yeah. All right, thank you guys, and good luck.